Hello, everybody. Welcome to another Cam Brewer event. My name is Mark. I am a friend of Cam's, here purely to help make this experience as painless as possible for you all. If you are new to Zoom, I encourage you to turn your video on so that we can all see each other and feel a bit of community happening. Definitely turn your chat on. There's windows at the bottom to turn video on and mute yourself and turn chat on and participants windows and do other various things in Zoom. So please do turn chat on. We will be using that as a vehicle to give you some information and to invite questions and interaction from you for Cam and for Val. Also, consider renaming yourself. It's not difficult. You can roll over your own video preview, find the little dots in the corner, or in the participants list, again, roll over your name and a little blue button will appear more, and you'll see the option to rename. And what we encourage you to do is A, use your real name so we know who you are, and maybe add where you're from. You'll notice in my name, it says Vancouver. With Cam, it says East Vancouver. Some of our team have, you'll notice that in brackets, they put the city they're in. Just helps us get a sense of where we're all coming from. And it's really interesting. So a couple of views you can switch in Zoom. You can switch between speaker view, which will be the person who's speaking most. Like right now, it's likely that you see my giant head as the primary video, but go ahead and experiment and click the top right. There's something called gallery view, which will allow you to see everybody and all of, if your videos are on, we get a sense of this small community we've convened together tonight. Don't be shy. Make as much noise as you can, bearing in mind that I have you muted and I have disabled your ability to unmute yourself. There will be an opportunity where we will be asking you to put your hand up. You can do that by waving at me. You can click the raise hand button in the application as well. And myself and my colleague Jonathan, you'll see, also has an asterisk before his name. We will pull some questions forward and some folks to participate in the conversation a little bit later. So with that, really just be respectful, ask the hard questions though, have some fun. And with that, I would love to introduce the next leader of the BC Green Party, Mr. Cam Brewer.
There we go. Thank you very much, Mark, and welcome everybody. Thank you for joining us tonight. I'm with you from my home in East Vancouver on the unceded traditional territory of the Squamish, Musqueam, and Tsleil-Waututh nations. And as Mark said, I'm running to be leader of the BC Greens. And for those of you who have followed along, you'll recognize that tonight's Zoom chat about Indigenous law, which is it's going to be really exciting and interesting. It's part of a series. So we started initially with Herb Hammond and I talking about forestry and ecoforestry and nature-based planning. We then moved on to education. Last weekend, Stephen Price and I had a conversation about that. There's actually an op-ed in the Tyee this week about the same subject. And then on Tuesday of last week, David Boyd and I talked about the right to a healthy environment. So it's this series in which we're engaging in some issues that are really important to British Columbians and front and center. And tonight's conversation about Indigenous law is, of course, exactly that. So if you missed any of the previous Zoom conversations, go to my website, cambrewer.ca, and under events, you'll see recordings. Tonight's is being recorded and will be available there, as will our future conversation. So to begin, I'm going to introduce, first of all, somebody who's familiar if you've watched any of those previous conversations, which is, her name's Anna Yamoka, a graduate of law in Oxford University and NYU. She's the communications director on our campaign, and Anna will be moderating the questions in the second part of tonight. So welcome, Anna.
Thank you. Great to be here.
Okay, and now it's my absolute pleasure to introduce a friend and a scholar and an Indigenous leader, Val Napoleon. Val is Cree from the Saulteau Nation, an adopted member of the Gitanyow, part of the northern Gitxsan here in BC. Val and I met about 20 years ago. We were both on the board of the Silva Forest Foundation working to advance ecoforestry, the conversation I had with Herb Hammond and the first of these chats. And Val and I, worked on that together. And part of our work on advancing ecoforestry was certification of logging activities. And a core principle, a core element of certification was free and informed consent from the indigenous people within whose traditional territory the logging was to take place. And at the time, Val had just made the decision, had just completed her going back to law school in mid-career, which I loved talking to her about it and learning about it. And she inspired me also to think about going to law school, which I also did later in life. And that's an unusual thing. Most people go to law school much earlier than Val and I did. But for both of us, it's worked out extremely well. And Val, of course, has gone on to great heights, finished her doctorate in law at the University of Victoria in 2009, and now runs the joint program, the JD Juris Doctor program, the traditional law program, with an Indigenous law degree as well at the same time. So it takes students longer, but innovative program. And also has established the Indigenous Law Research Unit, which she'll talk a little more about, I hope, partners with communities to help Indigenous communities articulate and identify Indigenous law. And it's part of a global movement with international connections to that program. So Val's been incredibly busy since I first met her, and it's really excellent to have her here tonight. So welcome, Val.
Thank you. I'm so glad to be here, and it's lovely to have started these conversations with you, Cam.
Well, thank you for your time. And before we get in, I'll just say a couple things that, to set the stage, as it were, based on the conversations we've been having and the thinking that's behind the platform that I released earlier early last week. And the platform has some really important pieces around Indigenous law that have been informed by our conversations, Val, and by, of course, others. And the starting place really is that Indigenous societies the world over have had legal orders that were part of their governance, part of their society. And so here in what is now British Columbia, there is in fact a plurality of these Indigenous legal systems that developed over thousands of years before Europeans arrived. And when Canada asserted sovereignty, Crown sovereignty in Canada, the Canadian legal system, the common law legal system here, and the civil law legal system in Quebec, there was already these legal systems existing in this place, and that Indigenous legal order didn't go away. Now, in some cases, it's become invisible. It's even, in some cases, been made illegal historically. But those Indigenous legal systems didn't disappear. And the Canadian legal system started to slowly recognize Aboriginal rights and Aboriginal title, but in the context of the Canadian state legal order, which is different. And again, the Indigenous legal systems didn't disappear and still remain. And then in 2015, the Truth and Reconciliation Commission recognized this, and in their definition of reconciliation being this ongoing process of maintaining respectful relationships, the TRC said, and I'll quote, that establishing respectful relationships also requires the revitalization of Indigenous law and legal traditions. So Val, maybe you can start out just explaining to us in a bit more detail what we mean by Indigenous law.
Whenever I'm asked that question, I have a whole bunch of possible answers. And so the first response is that Indigenous law is law. And it enables people, large societal scale groups of people, to manage all aspects of their lives. So whether it's how people govern themselves or manage disputes or families or other parts of the world that they live in with land and relating to other peoples and so on, like all of the ways that we manage ourselves, law as a distinct mode of governance within that overall way that we take care of our collaborative, collective business with one another. The big difference between Indigenous legal orders, which is how law is structured and the institutions through which Indigenous law operates, and the laws themselves, those legal orders for Indigenous peoples are non-state. So most Indigenous societies were decentralized without a big centralized governance. So what that means is that the authorities through political, legal, economic authorities were distributed. So there was definitely systems of law, but they look different. They do the work of law, they function as law, they have the different elements which enable law to exist, but they look different than what people are used to if they're more familiar with Canadian law, for example. So that's one answer. The other response that I would love to sometimes, and I sometimes ask people this too, is, would you ask that question of Canadian law? So, and I often, in teaching and in other situations, what I encourage people to do is, when you have a question about Indigenous law, which, and I invite questions, it's the way that we learn, right? But take a moment and think about, would you ask that same question of Canadian law or American law or, law in England or wherever? And if not, why not? Because that allows a little bit more insight into what are the terms of questions, terms of reference rather, that we're thinking through about how law is a part of the world and what our understanding of it is.
Well, that's a great lens on it, Val, of course, and thank you for both of those answers. I remember when I went to law school, not asking that question, I guess, and then finding out that how little I really knew about what the law is and where it comes from and what it means and the values behind it. So, for example, with the common law, that if someone's in trouble, say they're off the end of a dock by a lake and they're drowning, the common law has no requirement that I help that person. But on the other hand, if I do try to help them, I better not make it worse, because the common law would have something to say about that. But that original decision that the common law doesn't require me to take affirmative action to help somebody is a value choice. It's a choice that was made at some point that reflects values in society. So the points that you've described law in a different structure than perhaps what we're used to, I'm assuming also reflects values about governance and about authority and about relationships among people within Indigenous communities.
I think it's profound insofar as how we understand citizenship, how we understand people, and how we understand ourselves as legal agents in our worlds. So I think that when, part of what we see with common law, state law, is we see dedicated professionals responsible for the operation of law, for running the institutions through which law is manifested. And when you have non-state legal orders, when the institutions are kinship groups and clans and other forms through which people are organized, everyone is responsible for that legal order, to maintain that legal order and to ensure that obligations are met, to ensure that the legal processes regarding fairness or inclusion or anything else. And I don't want to idealize Indigenous societies, because that doesn't help. And we had law because we had all the same difficulties that every other society has insofar as conflicts and so on that we had to manage. But I think there's something that we need to think more about in terms of who gets to say what law is and who gets to understand themselves as mattering to the law in the world around them. One of the realities is that if you went to a household anywhere in Canada and you asked people in that household if they didn't have a legal education to tell you about Canadian law, it would probably be a very narrow conception of law insofar as enforcement or criminal law or other things that are more publicly visible. And I think that one of the goals of law is to have it as being part of everyone's life, so that law itself, with all of its promises and potential failures, is democratized. So democratized in a way that all the citizens believe and understand themselves as mattering to that larger legal order, it's not a matter of, well, I guess that's it, but people's agency would matter in a more profound, direct sense than they do now.
Right. Okay. So we've got these ideas then about what Indigenous law is, and you mentioned how it's structured differently and so on. How does Indigenous law, recognizing there's a plurality of Indigenous legal systems, how does it in general then relate to Canadian state law?
So in every geographical space anywhere around the world, there's more than one legal order operating in that legal space. And there always has been, historically and in the present day. So Indigenous legal orders relate to each other through all kinds of organized processes historically. Many of those continue today on at least an informal basis. The ways that it relates to Canadian law depends on which area of law you're thinking about. So if you look at criminal law, the state has created a monopoly for itself insofar as the ability to enforce laws, right? And so the ability for communities to determine their norms, their rights and wrongs, and then to collectively act on those, that's much more removed than today through the criminal legal system. But what you see in Canada are sort of phases in history where you see the suppression of Indigenous law, and then you saw efforts at community programming, and now you start to see at least conversations about how Indigenous law and legal principles might inform the reasoning processes of a court to solve a problem, which is a shift away from looking at Indigenous law as a fact or as evidence. So you see some through the court sets one way, but there's other ways as well in terms of how people are trying to structure the relationships between the state and different parts of Indigenous societies. There's also, so you see those kinds of services or political relationships and so on. So I think that there's a lot more potential for more practical and structured relationships between Indigenous peoples in Canada. I just want to raise what the Truth and Reconciliation Commission said about reconciliation. And basically, if we think about what reconciliation is and its possibilities, if Indigenous law is not a part of that conversation and is not conceived as mattering in its fullness to Indigenous people, then what reconciliation is informed only by state law or Canadian law. So, I mean, that's an example through which we can develop a construct for ways that people can bring what matters to them and how they organize themselves together. There are many others as well.
So to build on that then, when the TRC says it's important to revitalize Indigenous law as a way to do that, so that there's an equality, or certainly not an assumption or a presumption that Indigenous law is somehow inferior to Canadian state law. How does that revitalization happen? Maybe you can talk about, you know, your work with the clinic, but also more broadly as well. How can the state help, or at least not interfere with, the revitalization of Indigenous law to allow that reconciliation to advance?
Yeah, so I am the director for an amazing research unit, which works with Indigenous communities on questions that they have about their laws, about their legal orders. So it might be water, human rights, gender, child welfare, governance, lands, you know, so we work on a whole spectrum of legal issues as defined by Indigenous communities. So we support them to look at how, and to research and to articulate the substantive law as well as the legal processes from their legal orders. And we draw on the oral histories, we draw on the legal histories and legal resources from that society to make that articulation and restatement of Indigenous law around the questions that they're asking. What we do is we create a body of work which they can then use to inform water management systems, co-management systems, or environmental assessment systems, or child welfare structures, or anything else that they're working on, that they're building. So that's how we're doing the work. I guess, you know, as you said earlier, there is no intact Indigenous legal order in Canada or anywhere else. They've all been undermined, and lots have been distorted, and there's parts that are invisible. And so the work is to do actual rebuilding. And what rebuilding law means is rebuilding citizenries. It's rebuilding people being lawful according to their own legal orders and to their own legal principles, and so on. So I think that insofar as making a difference for Indigenous peoples, doing that kind of rebuilding of law area by area is absolutely critical. And I don't think that the work can be done without it.
And so you've now undertaken a number of these projects, you, not just individually, but you and your team and through the clinic, and been able to realize some success in that and some improved citizenry, as you say, and in situations. Are there things that you've learned from doing that would help kind of inform both future projects, but also what else could be done to support more of this?
I think that at every opportunity that people have, like whether it's in structuring an agreement with Indigenous peoples or figuring out another kind of working relationship around something that people care about, is to take the time and look at what are the legal perspectives on this topic or that topic from that Indigenous legal order, from those peoples, and to not look for an answer on complex legal questions, but rather to ask what are the legitimate legal processes through which people make these kinds of decisions. Like, how do people, if we understand law is fundamentally about problem solving, mm-hmm. then what are the terms of legitimacy, and how might those processes be supported for people to do that legal work in their communities?
So applying that legitimacy then to, you mentioned a minute ago, for example, environmental assessments that would be done in an Indigenous community according to Indigenous law and articulate that decision-making process. Would that then unfold in parallel to, say, a BC environmental assessment process? I know in the BC Act, there's now space for that the new legislation for that to happen, but would it happen in parallel, and how does that also kind of affect the joint decision-making or the shared responsibility for making decisions about resource projects, as an example?
Yeah, I think that the work to support Indigenous communities to research and articulate critically and rigorously laws governing areas of their lives, and then dealing from that informed basis of strength with any aspect of the federal or the provincial government will change the kinds of conversations that go on. Most of those conversations, it's assumed that there's a deficit on the part of Indigenous peoples, that the job of the government is to build our capacities as opposed to building their own capacities. And then what happens is that state law takes up all the space, takes up all the legal imagination, and anything beyond that is not even seen. So what we're doing is enabling communities to say, okay, this is an area of law. These are the authoritative decision makers around that area of law. These are the legal obligations that people have to fulfill in order to be lawful. These are the substantive and the procedural rights, and I know rights is problematic for many peoples and deserves more conversations. But so people can talk from that basis of informed strength as lawful peoples in order to push back all of the intrusions of Canadian law. And there may be areas where people decide to collaboratively, and they are collaboratively working on governance of water is a good example. There, perhaps human rights, perhaps aspects of criminal law, like people will find ways to manage themselves in a way that makes sense for today, to solve today's problems. So this work I'm talking about is not going back in time. It's to deal with the challenges today in a better way than they're being dealt with now.
So let's pick up on that point then. So around the not going back in time part, because when we've talked about this before, you've emphasized the importance of, just like Canadian law or all aspects of Canadian law, certainly constitutional law, but all aspects of law evolves as society evolves, reflects contemporary conditions and values. And that would then, as you've said, be part of the conversation of a contemporary articulation of Indigenous law in a particular place. And I'm assuming then in response to current objectives and values and concerns within an Indigenous society.
Yeah, so law has to change or it becomes irrelevant, or it can become oppressive, right? So it needs so if we look for instance at our human rights work, our work with human rights is not focused on state human rights, provincial or federal or the charter. What we're doing is looking at what are the ways that people understand dignity and inclusion and fairness and safety and all of these things from within the legal order, right? And again, assuming that there's it's not about a deficit, it's about a restating of law. But that we have to also draw on historic and Indigenous legal theories and ways of working with law, as well as other tools to think through same-sex marriage, to think through what are the ways, the legal tools within the different legal orders to understand ways of life that are required for today, for the kinds of decisions in the families and the mix of economies or whatever that people are having to deal with today. So yes, it absolutely has to change, or it'll get lost. And if it's oppressive, it should get lost.
Right. And if it's empowering, then it'll strengthen communities and build, just like any other area of law, we would hope. So how then does what you're talking about in the current articulation of Indigenous law fit with the UN Declaration on the Rights of Indigenous People? Is that what's envisioned in that declaration?
On a general basis, yes, it is. I just want to say, like, sometimes when I'm talking about our work with Indigenous law and the rebuilding and so on, sometimes we have people saying, "Oh my God, it's so complicated. Like, why would you want to do that work anyway? It's too hard. It's too complicated. It takes too long. It's too slow." We are doing the work. We've been doing the work since 2012, since we established the Indigenous Law Research Unit. We are teaching, we have an Indigenous law degree where students get that degree alongside a common law degree. So we're teaching, I teach Gitxsan land and property law. We have Anishinaabe constitutional law, Cree criminal law, Coast Salish torts. We have Tsilhqot'in contracts alongside Canadian contracts. So this is all work that we're doing now. Yes, it's complicated. It's no more complicated than working with Canadian law. So I just need to say that before going into talking about the declaration. The declaration, if you look at the terms, it's in broad, very broad brush strokes, so you can look at that as being supportive of all of the work that has to go on. But the work within the UN declaration, it's got to be broken down into smaller pieces, right, so that communities can do it step by step, and that we can support that work step by step.
What you said about the it's no more complicated than Canadian law, and it might also help with strengthening one's understanding and critical perspective on the law, because I certainly noticed when I was practicing international law as a common law trained lawyer, often the disputes would be in a jurisdiction that has civil law, and there's very different values behind it, and certainly different procedures. And that, thinking about those values and procedures, makes one question the common law system, and vice versa. And you can kind of come up with the best of both worlds, and at the very least be at least more critical or analytical about your own assumptions and the legal system. So maybe during those conversations you have in your classrooms, there's a strengthening all around.
I hope that people, every person should be able to ask, what makes this legal? What makes law legal? What's legitimate in my world and in my terms with my family, and how I support my family, and all of the ways that that people are making decisions formally and informally. Like there's, again, it's about democratizing law in every aspect of law, and its language and its power, and reclaiming that.
Okay, great. So I think we're about halfway through. Anna, should we move on to some questions from participants?
Yeah, that'd be great. We've got some really good questions coming through. So everyone, this is our audience participation part of the talk. Mark's going to help me out with throwing up a poll. We'd love to hear a bit more about you, how you're doing, where you come from, what your priorities are in these challenging times. So yes, if you could take a moment to answer that, that would be great. Gives us a sense of the community that's on the call. And then at the end of the Zoom call, we'll throw up the results, and they're completely anonymous. So. All right, so first is Lindsay Brown, who said, could you please discuss Indigenous and treaty law with respect to Site C and Treaty 8?
Sure, well, maybe I'll just jump in quickly, Val, and then let you add to this. The Treaty 8 First Nations, of course, are opposed to the Site C project for a wide variety of reasons, not least of which, or part of it anyway, is the $10 billion price tag, but also, the incredible environmental impacts and the diversion of the Peace River and so on, the flooding of land. But it's also the loss of the archaeologically important land, their territory, burial sites and sacred sites and grounds. And the other thing about treaty rights to keep in mind is that it's not just a single project at one point in time, because the cumulative effect of all kinds of projects since treaties were signed can have an aggregate impact on those treaty rights and erode them significantly. So often one of the things that happens, in my experience anyway, has been this idea that you look at just one project in isolation and whether that's going to, impinge on treaty rights, and then not consider all the permits and all the development that happened before that. But the question, I think, more, Val, is about the Indigenous law perspective on it as well, as not rather than the common law sort of approval process.
Yeah, thanks. It's a huge question. There are Danisa people in the northeast of the province, and along with the community I'm a part of, the Saulteau First Nation. There are Cree people, there are Mohawk people, and we moved across Canada over the last several hundred years, and had an arrangement with the Danisa people for us to be able to live in those lands. And so there are more than one legal order that's involved there. So one of my students, for instance, is looking at Dene law or slavery law and Cree law, because those are from a Indigenous legal perspective, that's what she has to look at for law up in Fort Nelson. And then she has to look at what are the connections with the surrounding people, because there's intermarriage and historic and present day relationships. Near where the Site C Dam is, you also have those multiple legal orders with different ways that people organize and govern themselves, and also govern the ways they make decisions regarding land. So I guess the first step in any of these kinds of situations is to ask, what is legal according to the Indigenous peoples or Indigenous legal orders of an area? So is the Site C Dam legal according to Cree law or Saulteau law or Danisa law? And so, do you know enough about that legal order to be able to answer that question? And the answer is no, because that research hasn't yet been done. We're working, it's one of the projects that we have up there, is to articulate the land laws that people have, Danisa and other peoples in that region, the land laws that they have. And given where the political economic decisions have been reached insofar as that project, it's not as if they're going to be able to use their laws to push back the state laws. But what might they be able to do with the laws, of their own laws articulated, insofar as dealing with any other responsibilities that they have with regard to that river, with regard to the animals, with regard to that whole landscape. I mean, the other thing that the dam is doing is wiping out the moose calving grounds. And that's very significant for people there.
Thank you so much, both. So the next question, we have two longer questions, which I think are related insofar on maybe they touch on questions of jurisdiction. So I'll just read them now. So we have one from Sarah Robinson, who asks, in the work ILRU has done with various nations, how have communities wrestled with or discussed how their legal orders may apply to both Indigenous and non-Indigenous peoples within one geographic space? For example, taxation, citizenship, ability to vote, etc. And then Peter Collins asks, How are Indigenous law jurisdictions identified, and how do you envision those working alongside other jurisdictions, federal, provincial, municipal, within Canada today and for the future? And he says, I'm not a lawyer, so hopefully my question makes sense.
Well, Val, I'll let you answer most of that, but I will make a comment about the last one, which is that we have a tradition, even in the Canadian state legal system, of cooperation. So the Canadian system not only has civil law and common law, says our state systems, but we have federalism in Canada, which means that some things, of course, are under the jurisdiction of the federal government, which is why we had the TMX pipeline continuing through this province. Some things are in the jurisdiction of the provincial government. Some of the provincial authority is then delegated to municipalities. Cities get all their authority and regional from provincial authority in the Constitution. So we already have this idea embedded in the way that Canadian legal system works with cooperation and with overlapping decision making, and this need really to make it work properly is with cooperation rather than opposition. That's the theory anyway. And Val, I'll turn the rest over to you.
Okay, it's so interesting. One of our projects that we're working with about, I guess, 9 or more Indigenous communities is on citizenship and belonging. So, and it's doing that research with the language. So drawing concepts, legal concepts from the words themselves, and as well as drawing from the oral histories and so on. So it's looking at how did Secwepemc people understand who's a citizen of that people. And so, and the way that that research is going is to figure out how do you know you belong? How do you know that you're a part of that people? And so that work it's still in draft stage. But those are, that society had citizenship laws. It's the same as the Gitxsan people had citizenship laws, and different forms of democracy at work within those political systems as well. So the big questions about then, once that's articulated, then how does that relate to Canada? That's got to be on a case-by-case basis, law-by-law basis. There's not going to be, peoples organize themselves differently. So is it going to be figuring out how non-Indigenous communities are part of a clan system, and who's responsible for a river? There's so much more thinking and development of a bigger legal imagination than we presently have to solve those kinds of problems, like taxation. Indigenous peoples had forms of taxation. How does it relate to the Canadian forms of taxation? Well, I don't know that. I don't know yet what that's going to look like. Similarly with, the problem, as you probably know, is that while we had citizenship laws and economies and political ordering and so on, and legal institutions, we have imposed on top of all of it federal law through the Indian Act, which has undermined and imposed other ways of other forms of structuring, and there's been a political reorganization as a result of that. So there's all of that has to be figured out. One of the things that I do, and one of my papers, is I take, like if we look at historic legal orders and law, and then contemporary legal orders and law, then on each area of law, you've got to figure out what principles are going to be brought to bear to sort out this aspect of it. And you do it step by step. There's no easy way through that.
No, there's no easy way through any of this. And the other listening to you speak too made me realize, it reminds me that, of course, the legal system within Canada, even the state legal system, doesn't just end at our borders. It's informed, of course, by international law. So we look at UNDRIP. It's informed by the history of the common law going back 800 years to the Magna Carta and the history of what judges have done in that context, which informs big areas of our law that isn't set by people we elect, either provincially, municipally, federally. So there's lots of different streams coming together, and a richness can come from that if there's a dialogue and a cooperation and a recognition of these different systems at the same time.
Great, thank you so much. So the next question is from Hannah from West Van, and it's Cam. As leader, what are your plans for enabling economic development for Indigenous peoples?
Well, thank you, Hannah, for that question. Part of it starts, of course, with what we're discussing here with Val, by supporting the revitalization of Indigenous laws, in my view, the way that we'll get to not only justice, but certainty and a richer system for everybody. So that's sort of the starting place. And then having Indigenous land management, as we've seen in many places, even from a biodiversity perspective, land that's managed by Indigenous people around the world have been shown to have greater biodiversity within that land than parks and protected areas. So there's great sort of environmental benefits to that, obviously. And then combining Indigenous land management with nature-based planning, which is what we were talking about with Herb Hammond, the earlier conversations, and that Val is quite familiar with as well, allows for that long-term stewardship of land that creates more stability and jobs and economic development. And then, of course, supporting Indigenous entrepreneurs, the idea of a green bank that would provide innovative funding and support for Indigenous entrepreneurs and development and clean innovation incubators. All these pieces combine and reinforce each other and get to a place where we have, lasting justice, recognition of the legal plurality that's here, and of course, long-term stability and economic development.
Great, thanks, Cam. So Michelle asks, what is the difference between Indigenous law and Aboriginal law? Is this distinction recognized in the courts?
So one way to think about it is that Aboriginal law is Canadian law about Aboriginal issues. Okay, so it's Canadian court decisions and jurisprudence about Indigenous issues, lands or whatever. And so it develops things like the Aboriginal title test and Aboriginal rights frameworks that then, you can go through that system to try and attain that recognition. Indigenous law comes from Indigenous societies. So it comes from the structure of those societies, the institutions, their legal history, and so on. So, and it's important that you think about that on a societal basis. So for instance, there's a Gitxsan society. There are 6 smaller Gitxsan communities. There's a Tsimshian society, and there are 7 Tsimshian communities. And then, all across Canada, you have different Indigenous societies and smaller communities within them. And so the law from those societies, through time, is developed as people have managed themselves. Come.
Thanks, Val. Hello.
Hi.
Another participant in the call. That's great.
Earlier, I made him watch Mi'kamosis, Mi'kamosis in the Wetago, which is about Cree law. And then we read Nutsamat, Cowichan Water Lawyers. Both of these are our new graphic, or the Nutsamat is our newest graphic narrative. We have teaching guides to go with them, and that will soon be publicly available.
That's fantastic. Another lawyer joining the call. So this is a question from Matthew Morin to Val and to Cam, which is, how do you plan on participating in the legislation of UNDRIP, and what organizations will you be working with in order to effectively participate in this process?
Well, I supported the development of that legislation through its earlier steps, and then I encouraged it. Insofar, and I think what's important about it is that it creates opportunities for more conversations between, and more dialogue about all manner of things that we need to work on. I don't think that it's going to provide all the answers for the complex problems that our society is experiencing. Insofar as which organizations I'm going to work with, I'm going to continue my work with the Indigenous Law Research Unit, which is a dedicated research unit at the law school here at the University of Victoria. And, I have several other organizations that I work with that are international, and I'll play a supportive role wherever I can.
And Val, maybe you could sort of explain what's happened with some of the graduates from the program. Are they then helping as we move towards really taking seriously the articulation of Indigenous law, and with the with UNDRIP and so on? Where are they ending up practicing?
So the Indigenous Law degree program, the dual law degrees, we're just coming into our third year, and it's 4 years to graduation. So we don't have any graduates yet, but we have hired a whole bunch of them. They've been working with us all summer, doing the Treaty 8 project, the Cowichan project, like working with us on all different areas of work. We have we also hire JD students, like in the other program. Oh, goodness sakes. And okay. So and then the law firms snap them up just as fast as they can. So
I bet.
Those students are everywhere, which is pretty wonderful, actually, because they're out there doing the work, the hard work of law, whether it's in business or whether it's in politics or governance, the local governance, or so on. There are amazing students doing amazing work.
That's fantastic. Thank you. So Frank from Prince George asks, what is the Indigenous data sovereignty plank in your platform?
Oh, great. Okay. Well, Frank, it's really about self-determination. And the idea is that it's a global movement that has to do with the creation, the collection, the ownership, and the application or distribution of data. And as we're globally in a society in which governments have a lot more use for data, collection of data, there's privacy issues, there's concerns about what data is going to be used for what purpose, Indigenous people should have that authority to make those choices, to ensure they're the ones that decide what data is going to be collected, what it's going to be used for, and how it's going to be shared. And so that's really the whole idea behind it. And it really makes sense as we move to having more data globally. So it's part of this international movement, and in British Columbia, part of my platform is to ensure that that's put in place to be able to give Indigenous people that sovereignty over their own voices. And it's in the context too to understand that oral histories and oral cultures might have a different approach to data and collecting it and turning it into a non-oral form than otherwise. So Val, do you want to add to that?
That's one of the most interesting and complex questions that I have within property law. So I mentioned that I teach Gitxsan land and property law which includes Gitxsan intellectual property. But if you look at what, according to a Western legal lens, would be intellectual property, it's actually the structure of governance, right? They're actually legal precedents, and yes, they're from one legal perspective, they can be seen as intellectual property, but from another legal perspective, they're institutions and they're collective memories, and they're a whole lot more. They're about how people are structuring their political systems. So having said that, there are all kinds of copyright or intellectual property issues that people are sorting out that are really important for Indigenous artists, as well as, you know, collectivities, and so, I mean, that's another whole field that is yet to be taken up. There's the Yellowhead Society, Yellowhead Group has just put together a major report on Indigenous intellectual property issues that you might find helpful.
That's great, thank you. So Jim Hesser in Saanich says, Val, thank you, this has been very interesting. Are there specific actions that you would recommend BC Green members, and I guess we can expand this to, you know, everyone on this call, undertake or incorporate in our efforts to improve BC?
So build into every public conversation that there is an Indigenous legal order, or perhaps more than one in that space, that there are Indigenous legal perspectives on virtually every topic of collective human life and individual human life for that matter. That when issues come up, instead of just thinking about how Indigenous people have to relate to Canadian law or what Canadian law says about an issue, to think about and to ask, what is the Indigenous legal perspective on this question, and what do I need to know in order to be able to answer that question? And wherever possible, engage in the uncomfortable conversations that we all are going to have in order to productively live together.
Thanks, Val. And I think that probably segues well into what might be our last question, which is from Mark in Nanaimo, which is to Cam, and it says, why are Indigenous law and Indigenous rights such an important part of your platform?
Well, it's going to be hard to make it more clear than what Val just said. I think it has to be part of the platform. It has to be, it's a responsibility of everybody here to take this seriously and to recognize the fact of pre-existing legal systems, societies that you hear for thousands of years. And so on a more personal level, in my experience as well, I guess, starting back, as I mentioned at the outset, working on ecoforestry and certification in BC and working with Indigenous people in that process and learning about the importance of that and learning about the dialogue that's necessary and the consent piece from certification. As a consultant, before going to law school, I did a lot of consulting work, including with Indigenous people on specific projects and with Indigenous health issues, for example, not just resource issues. And then now as a lawyer, I practice so Aboriginal law from a Canadian legal perspective, but our clients are almost entirely, a vast majority anyway, Indigenous people working on a range of issues, including, for example, with the Trans Mountain Pipeline, trying to stop that. So on a personal level, there's been lots of experience working with Indigenous people and at a professional level, sorry, and then on a personal level, having friends like Val, which inspired me in going to law school later in life and seems like a great thing to have done. So for many reasons, but it really comes back to what Val has already said about the necessity of this for all of us.
Great, thanks, Cam. I think we're probably top of the hour, so I'll hand it back to you to wrap us up.
Great, okay. Well, thank you, Anna, for doing a wonderful job again. Thank you, Mark, for taking care of things behind the scenes. Thank you for everybody joining. And Val, incredible conversation. Thank you for sharing. Thank you for trying to educate, which is so important. And thank you for your time tonight. So this is part of my campaign. As we all know, there's been a series of these Zoom conversations. The point of this campaign has always been about showing and advancing the important notion that we are not separate from nature, we're part of nature, nor are we separate from each other. And a huge component of that is with Indigenous people and supporting the re-articulation of Indigenous law. If you like what you've seen in this conversation and the previous ones, please go to my website. There's more information there. If you like what you're hearing, please sign up to vote. You can go to cambrewer.ca and click on Vote for Cam. Encourage your friends to vote, your family to sign up to vote. There's only about 10 days left for the cutoff for you to participate, and it's available to anyone who wants to participate in the province. You don't have to pay any money. You don't have to join the party. It's 14 and 15-year-olds can join the party. Anyone else can vote without having to join. So thank you, everybody, for tonight, and have a good rest of your weekend.